Municipalities. Section 156 was repealed in 1994. At the time of repeal it said, cities divided into 6 classes, general laws to be made for each class, population limits for classes, assignment to classes, organization of cities. Section 156A. General Assembly authorized to provide for creation, governmental structure, and classification of cities. The General Assembly may provide for the creation, alteration of boundaries, consolidation, merger, dissolution, government, functions, and officers of cities. The General Assembly shall create such classifications of cities as it deems necessary based on population, tax base, form of government, geography, or any other reasonable basis and enact legislation relating to the classifications. All legislation relating to cities of a certain classification shall apply equally to all cities within the same classification. The classification of all cities and the law pertaining to the classifications in effect at the time of adoption of this section shall remain in effect until otherwise provided by law. The previous 3 constitutions contained no provisions dealing with municipalities, and the General Assembly issued individual charters to each city and town wishing to be incorporated. By 1890, there were hundreds of such charters, which contained a hodgepodge of different powers and institutions. In order to fully understand the law of municipal corporations in Kentucky, a lawyer would have had to have read and mastered the nuances of each of these multifarious and often lengthy charters, a formidable task at minimum. Desiring to provide for a uniform system of municipal government, but believing that the powers of city governments should depend to some extent on the size of the city, in Section 156 the framers of the current Constitution divided cities and towns into 6 classes according to population and mandated that the General Assembly should enact a uniform law of government for each class. Modern legislators regarded the population classification requirement of Section 156 as too inflexible and proposed by constitutional amendment a more flexible criterion based on population, tax base, form of government, geography, or any other reasonable basis. Voters approved this amendment in 1994, thus repealing Section 156 and adding Sections 156A, Flexible Classifications, and 156B, Municipal Home Rule. In 1996, in an action before the Clark County Circuit Court, the Attorney General unsuccessfully sought to invalidate the amendment on the grounds that voters had not been adequately informed as to its nature, the ballot language having failed to state that the amendment would eliminate the requirement for voter approval of long-term local indebtedness. In July 1998, the Kentucky Court of Appeals affirmed the decision of the Circuit Court, Chandler v. City of Winchester.
Section 156B. General Assembly authorized to permit municipal home rule for cities. The General Assembly may provide by general law that cities may exercise any power and perform any function within their boundaries that is in furtherance of a public purpose of a city and not in conflict with a constitutional provision or statute. Voters approved a local government constitutional amendment in 1994 that added this section empowering the General Assembly to grant home rule to cities, which the General Assembly had already done in large part by statute in 1980. This section gives the legislature specific constitutional authority to do so and eliminates doubts about the constitutionality of the 1980 statute. Home rule grants to cities the authority to deal with their local problems and represents a significant measure of independence from state supervision. Before the home rule reform took hold in the 20th century, American cities were beholden to state legislatures for statutory permission to carry out many of the routine requirements of municipal government. There are no published judicial opinions concerning this section.
Section 157. Maximum tax rate for cities, counties, and taxing districts. The tax rate of cities, counties, and taxing districts, for other than school purposes, shall not, at any time, exceed the following rates upon the value of the taxable property therein. For all cities having a population of 15,000 or more, $1.50 on the $100. For all cities having less than 15,000 and not less than 10,000, $1 on the $100. For all cities having less than 10,000, 75 cents on the $100, and for counties and taxing districts, 50 cents on the $100. constitutional reformers complained that during the period of the Third Constitution, 1851 to 1891, local governments taxed excessively in order to finance risky investments in railroads and other so-called public improvements. In response to these complaints, the framers of the current Constitution in Section 157 placed specific limitations on the ability of cities, towns, counties, and taxing districts to tax, which allowed larger cities and towns to tax more than smaller entities. The voters approved a constitutional amendment in 1994 that deleted from Section 157 provisions allowing local entities to exceed the taxing limitations in order to pay off indebtedness contracted prior to the adoption of the current Constitution and requiring approval by two-thirds of the voters of any indebtedness contracted by local government in excess of that government's annual income and revenue. Recognizing that it would be difficult, if not impossible, to secure two-thirds of the vote, local governments, which needed to borrow money to build needed facilities such as jails and courthouses, circumvented the requirement by having state agencies or specially created shell corporations borrow the money and build the desired facilities. The governments then leased the facilities from the agency or corporation, with lease payments equaling the payments due on the debt. The Kentucky judiciary ruled that these methods of evasion did not violate Section 157, for example, White v. Common Council of the City of Middlesboro, 1967. However, the evasion increased borrowing costs because local governments often had to pay lawyers to set up shell corporations. They also had to pay higher interest on the bonds, which were riskier since they were not guaranteed by general revenue of the local government. Supporters of the amendment believed that the deletion of the voter approval requirement would lower debt service costs for local governments because interest rates on debt guaranteed by the general revenue of local government are generally lower than rates for debt supported only by revenue produced by the project for which the debt is incurred. In 1996, in an action before the Clark County Circuit Court, the Attorney General unsuccessfully attempted to invalidate the 1994 amendment on the grounds that voters had not been informed that it would eliminate the requirement of two-thirds voter approval for long-term local debt. The Attorney General appealed the ruling to the Court of Appeals, which affirmed the decision of the Circuit Court in July 1998, in Chandler v. City of Winchester. The tax limitation provisions of this section have produced much litigation. The Kentucky judiciary has held that limitations on municipal tax rates have no application where a court orders a city to levy a tax to pay a judgment incurred because of liability for injury to a person or property. In City of Catlettsburg v. Davis, Administrator, 1936, and that Section 157 does not apply to public institutions that depend on the state for support, in McDonald v. University of Kentucky, 1928. However, a city may not exceed the tax limitations of Section 157 to pay a judgment for failure to pay for goods purchased, in Town of Mount Vernon v. General Electric Supply Corporation, 1942. Section 157 does not apply to special assessments for road improvements, which for purposes of the limitation, are not considered taxes, in Shaver v. Rice, 1925. An urban county government is subject to the tax limitations imposed by Section 157 upon cities having the same population, subject to such more restrictive limitations as the General Assembly may see fit to impose. In Jacobs v. Lexington Fayette Urban County Government, 1977.
Section 157A. Credit of Commonwealth may be loaned or given to county for roads. County may vote to incur indebtedness and levy additional tax for roads. The credit of the Commonwealth may be given, pledged or loaned to any county of the Commonwealth for public road purposes, and any county may be permitted to incur an indebtedness in any amount fixed by the county, not in excess of 5% of the value of the taxable property therein, for public road purposes in said county. Provided said additional indebtedness is submitted to the voters of the county for their ratification or rejection at a special election held for said purpose, in such manner as may be provided by law, and when any such indebtedness is incurred by any county said county may levy. In addition to the tax rate allowed under Section 157 of the Constitution of Kentucky, an amount not exceeding 20 cents on the $100 of the assessed valuation of said county for the purpose of paying the interest on said indebtedness and providing a sinking fund for the payment of said indebtedness. Until the latter part of the 19th and early part of the 20th centuries, many roads in Kentucky were privately owned and operated. The purpose of this section, which was added by amendment in 1909, was to authorize counties to tax with voter approval in order to raise funds to purchase privately owned turnpikes and to build and maintain additional roads to accommodate automobiles, which were fast becoming the preferred mode of transportation for most Kentuckians. Since 1945, counties have utilized this section less often because in that year voters approved an amendment to Section 230 that set aside revenue from gasoline taxes and motor vehicle license fees for highway construction, maintenance, and repair. Section 157A changes and annuls Section 177, insofar as it forbids the Commonwealth to lend its credit to the counties for the construction of highways and authorizes the credit of the Commonwealth to be pledged for construction of county highways and the Commonwealth to levy a tax to help pay for county roads, in Mitchell v. Knox County Fiscal Court, 1915. Section 157A only requires a majority of those voting in a special election to approve the issuance of road bonds, in Bowman v. Fayette County, 1916. The Kentucky Court of Appeals ruled that Section 157A permits a county to incur indebtedness for road purposes to the extent of 5% of the assessed value of the property, provided it can be paid with the 20-cent tax authorized by the section, which can be done as an additional indebtedness to that which may be created under Section 158, in Byrd v. Wilson, 1916. In 1982, the Attorney General affirmed that an election to secure the approval of voters for a special road tax under Section 157A may be held on a day other than that designated for the general election.
Section 157B. Adoption of budget required for cities, counties, and taxing districts, expenditures not to exceed revenues for fiscal year. Prior to each fiscal year, the legislative body of each city, county, and taxing district shall adopt a budget showing total expected revenues and expenditures for the fiscal year. No city, county, or taxing district shall expend any funds in any fiscal year in excess of the revenues for that fiscal year. A city, county, or taxing district may amend its budget for a fiscal year, but the revised expenditures may not exceed the revised revenues. As used in this section, revenues shall mean all income from every source, including unencumbered reserves carried over from the previous fiscal year. And expenditures shall mean all funds to be paid out for expenses of the city, county, or taxing district during the fiscal year, including amounts necessary to pay the principal and interest due during the fiscal year on any debt. Voters added this section by amendment in 1994 as a part of a local government reform amendment. The section requires local governments and taxing districts to adopt an annual budget and to keep expenditures within revenues. There have been no reported appellate cases about this section.
Section 158. Maximum indebtedness of cities, counties, and taxing districts, General Assembly authorized to set additional limits and conditions. Cities, towns, counties, and taxing districts shall not incur indebtedness to an amount exceeding the following maximum percentages on the value of the taxable property therein, to be estimated by the last assessment previous to the incurring of the indebtedness. Cities having a population of 15,000 or more, 10%. Cities having a population of less than 15,000, but not less than 3,000, 5%. Cities having a population of less than 3,000, 3%. And counties and taxing districts, 2%, unless in case of emergency, the public health or safety should so require. Nothing shall prevent the issue of renewal bonds, or bonds to fund the floating indebtedness of any city, county, or taxing district. Subject to the limits and conditions set forth in this section and elsewhere in this Constitution, the General Assembly shall have the power to establish additional limits on indebtedness and conditions under which debt may be incurred by cities, counties, and taxing districts. Voters approved an amendment to this section in 1994 as a part of a general reform of local government. The amendment retained the same categories of cities but referred to them by population, not classes, retained the emergency clause and the clause about renewal bonds and the floating debt, and empowered the General Assembly to impose further limitations and conditions on the indebtedness of local government. The amendment eliminated language found in the original section that addressed the local debt existing at the time of the adoption of the current Constitution. The framers of the current Constitution limited the indebtedness of local governments because some cities, especially Louisville, and more than a few counties had contracted excessive debt in order to invest in railroads and other schemes, some of which had failed. The delegates believed that the limitations adopted would facilitate the sale of bonds to finance future debt. Local governments evaded the limitations of Section 158 by selling revenue bonds financed by the revenue of the facility under construction and not guaranteed by the government itself, a mechanism upheld by the Kentucky judiciary in Baker v. City of Richmond, 1986, or by creating private corporations to build the desired facility and to sell the bonds to raise the money to do so. A method also held not in violation of Section 158, in Waller v. Georgetown Board of Education, 1925. This section has no application to assessments for public improvements such as sewers, in Shaw v. City of Mayfield, 1924, and it allows indebtedness in excess of the limitation in case of emergencies, as in a case where a city had been subjected to severe floods and needed to borrow to build a flood wall, in Hill v. City of Pineville, 1951. Pursuant to Section 158, in 1996 the General Assembly enacted a statute that prohibits a county from contracting indebtedness in excess of 0.5% of its taxable property without securing approval of the state local debt officer.
Section 159. Tax to pay indebtedness in not more than 40 years must be levied. Whenever any city, town, county, taxing district or other municipality is authorized to contract an indebtedness, it shall be required, at the same time, to provide for the collection of an annual tax sufficient to pay the interest on said indebtedness, and to create a sinking fund for the payment of the principal thereof, within not more than 40 years from the time of contracting the same. This section represents one further limitation on local indebtedness added to the Constitution in the light of the debt crisis of the post-Civil War period and requires local governments to pay off their debt within a 40-year period. The General Assembly cannot limit by statute the life of county bonds to be sold to pay off indebtedness to a period less than 40 years, the period specified by Section 159, although the local government can do so, in Fiscal Court of Estill County v. Debt Commission of Kentucky, 1941. Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution, by Robert M. Ireland, Oxford University Press.